Hello everyone, I welcome you all at Swayam platform. We are here to discuss a course titled as Hindu Personal Law including marriage and succession. We are in the second week where we are focusing on source and the school of Hindu law. Today we will focus on the custom as a source of Hindu law. But before starting anything, I want to summarize the last lecture. In the last class, we tried to understand the contribution of the commentator and digest writers in order to develop and evolve the Hindu law. Commentators and digest writers, without claiming any kind of delegated power, they interpret, aids, explanations, necessary qualification in the Smriti's text. Therefore, due to the scholarship and sadachar of the scholars, their explanation and interpretations enforced by the king in administration of justice. Due to the contribution of commentary and digest, Hindu law developed during 700 to 1700 AD. Therefore, we discussed detail about the commentary and digest in the last class. Today, we are focusing on the custom, especially on the custom as a source of Hindu law. Before starting anything, I want to focus on the learning objectives of the today's class. The learning objectives of the today's class includes meaning, definition and importance of custom, the concept of Sadachar in Hindu law, the approach of Supreme Court and legislation on custom, the kind of custom and essentials of the valid customs. These are the learning objectives. We will explore throughout the discussion what are the essentially required objectives. Therefore, custom is recognized as a source of law. Before starting anything, I want to explain the meaning and the concept of the custom. Friends, literally long established practices of the community and the member of the community considered as a custom. Custom may be defined as a way of behavior which a particular group or a society had for a long time. Therefore, Mullah defines custom as a rule which in a particular family or in a particular class or community or in a particular district has form long use obtained in the force of law. How we can define the idea of custom? Custom means continuity. Due to the continuity and due to the acceptance by the people, we recognize custom as a force of law. Therefore, literally on the basis of the practice of the community and the member of community, we recognize the custom. If we think about the meaning of customs and definition of custom from the perspective of the modern law, I want to tell you that three legal provisions that define the custom, which includes section 3A of the Hindu Marriage Act 1955, section 3A of the Hindu Adoption and Maintenance Act and section 3D of the Hindu Succession Act defines the custom. How they define the custom? As per the provision of section 3A of the Hindu Marriage Act, the expression custom and uses signify any rule which having been continuously and uniformly observed for a long time has obtained the force of law among Hindus in a local area, tribes, community and group of family, provided that the rule is certain and not unreasonable or opposed to the public policy, and provided further that in the case of the rule applicable only to the family, it has not been discontinued by the family. So, a statute in India first time defined the custom under the family law, where we understand that a custom may be considered a custom on the basis of the continuity and uniformity, and observance of the custom. So continuity, uniformity and observance of the custom practices provides a status of custom. Friends, now I want to focus on the concept of the custom under the Shastric Hindu law. According to Hindu law, custom literally means sadachar, and according to Harita, the word sat means good, and good people are those who are free from evil. The conduct of these people is called sadachar. The synonyms used for the shistachar is sadachar. Therefore, the conduct or a custom of shist people is known as sadachar. Now, important point is how we can define the concept of the shist people. According to the Bodhayan, the shist people are those people who are devoid from jealousy and egoism and liberated from desire, pride, greed and anger. I want to clarify you that in Bharatiya traditions, generally we use the term sadachar. Sadachar means behavior of shist people, and behavior of shist people is known as shistachar, and shistachar and sadachar both are synonyms, and therefore we also discuss according to Bodhayan who is the shist people. Friends, on that basis we are able to compare the concept of sadachar with the custom. Therefore, this slides focus on the custom vis-a-vis sadachar. Friends, custom in the Western legal tradition refers to the long-lasting unwritten practices that have been constantly followed over the time and have come to be recognized by the court as a legally binding. It is pertinent to highlight the fact that the Western legal approach do not prescribe the criteria of value or virtue that is considered by Bharatiya jurisprudence. Moreover, the criteria for recognizing custom as an source of law differ between the two legal systems. In the Western legal system, for a custom to be considered valid, if it must meet certain obligations such as having exist since time immemorial and not conflicting with the public policy. But in contrast, Bharatiya jurisprudence considered a custom valid if it is constantly followed by the shist people. So, this is the Western notion of the idea of custom, where they identify the idea of custom on the basis of continuity and time immemorial. But in contrast, Bharatiya jurisprudence have a different concept about the sadachar, which Indian people treated custom. Friends, Manusmriti in chapter 12 state that shist are those people who know the Vedas along with its supplement like Mimamsa and Nyaya. And Manu in chapter 2 further state that this path is meant for individuals who are not motivated by the pursuit of the wealth and sexual pleasure, but who are devoted to understanding and living as per dharma. Those who are living as per dharma, those are not affected by the wealth and sensual pleasure, their behavior is considered as a shist, as a shistachar. Therefore, the conduct of such a person could have the authority of law if not contravenes the Shruti, that is Ved. Bharatiya jurisprudence established the principle that in the absence of the sovereign or the written law, people should follow the conduct of a shist person. The conduct of such person will be regarded as a guiding law for the community. So, this is the difference between the idea of sadachar and the custom. Bharatiya recognize sadachar as a custom where you bound to follow the behavioral practice of sist people who have knowledge about Shruti, about Mimamsa, about Nyaya. Conduct of those persons should be followed by the people in absence of any sovereign law or in absence of any textual law. But in the Western concept, what has been observed for a long time should be followed by the people, because what observed for a long time have a legal force. They recognized such kind of phenomena as a custom. Therefore, friends, I want to explain you that both system of jurisprudence defines custom differently. Western jurisprudence focus on the behavior observed for a long time, but Indian context, the conduct of sist people in absence of sovereign law and textual law should be followed. This is Sadachar, and Sadachar is considered as a source of law. We discuss about the Manu and Yagyavalk, where Manu and Yagyavalk use the term Sadachar as a source of law, and Sadachar is a literally may be defined in such way. Now I want to focus on the basis of the following of custom or Sadachar. Why we are following the Sadachar? The Sadachar as a source of law observed by those who are sist, because it is observed, practiced by the sist people, therefore it should be followed by the people living in a society or in community. This is one basis of the following of Sadachar. The second basis is custom have been approved by the public in general, because public recognize the scholarship of a person, Sadachar of a person. So therefore, it originated because of the conduct of sist people. Public recognized this, therefore it should be followed. Why it should be followed? Mahabharata emphasize a instance where we focus on that tarko pratisthati srutiyo vivinna naeko muniyasya vacham pramanam dharmasya tattvam nihitam guhayam mahajano en gata sapantha. Friends, the idea is very clear. The number of argument is there. We have a different kind of Shrutis. We also have a different kind of the opinion of the scholars, sages. What is the problem? The problem is dharmasya tattvam nihitam guhayam. The principle of dharma is so secret, and therefore follow the path of Mahajan, means great people. I already explained the phenomena in the slides, friends. This sloka of Mahabharata tell us how difficult it is to decide what is good or bad. Logic is unstable. That is, one is bound to respond through his conditioned mind, and in a case of rishis, they are not affected by the 6 enemies of humans. Therefore, the conduct of the rishis can be taken as an authority in a case. The philosophy of dharma is very difficult to understand, so the path followed by the great people is the right path. Therefore, we should follow the custom or Sadachar. So, by this discussion, we are able to understand that why Sadachar to be followed by the people. Sadachar is a source of law, where we have no sovereign law as well as no textual law. Absence of sovereign law and textual law, we should follow the Sadachar. Sadachar means conduct and practice of sist people. They are great. Therefore, in order to know or identify the dharma, the conduct should be followed by us. This is the logic and justification for which we may follow the custom. Now I want to focus on the different kind of custom. Custom broadly categorized in 3 broad categories: local custom, class custom and family custom. Local custom means such customs belongs to some particular locality or district, and they are binding on the inhabitants of such place. Therefore, the custom is known as the local custom. Means custom of a particular locality is a local custom. In a case of Srimati Subhani versus Nawab, the Bombay High Court let down an observation, friends. The court observed that what is necessary to prove is that uses has been consistently followed from a long period, showing that by general agreement it has been accepted as the established governing rule in the specified area district. The court further observed that it is undoubted that a custom observed in a particular district derives its force from the fact it has for long use in that district obtained the force of law. The local custom means custom of a local area, custom of a district. Because of the observance of the customs, it acquired legal force, and therefore people residing in particular locality is bound with the customs. Now second is the class custom. The class custom means such customs may belongs to the specific caste, sect or group of individual engaged in particular profession or occupation such as agriculture, trade, art, etc. Class custom is associated with a class where we followed the practice which is prevalent within the class members. Now third is family custom. Such custom relates to a particular family. We should not mistaken when we are using the expression family custom. Family custom not mean that a custom which is followed by the family. Family custom means custom of a particular family which is binding on particular family. All family have a different practice and another family have another practice. Therefore, family customs may be understand, explain on the basis of a practice of a particular family. This is family custom. In the context of family custom, the consensus of the opinion among the members of the family is required. To establish family custom, the traditional beliefs practiced by the family along with their statements and the conducts are all considered relevant evidence in order to establish whether this comes under the category of family custom or not. Friends, in a case of Hari Prasad versus Seo, as referred by the mullah, custom means family custom is a rule in a particular family or in a particular district has for long use obtained the force of law. It must be ancient, certain and reasonable. In reference to the family custom, section 3A of Hindu Marriage Act especially provides a line. Therefore, section 3A of Hindu Marriage Act focus on provided further. In a case of a rule applicable only to a family, it has not been discontinued by the family. Means if you are claiming that you are the follower of family custom must not be discontinued. Means continuity is additional requirement in a case of family custom. Now I want to focus on the importance of the custom in Indian legal system. Friends, the first time in a case of Collector of Madurai versus Muthu Ramalingam, Privy Council attached more importance to the custom than the Smriti, and according to the Judicial Committee of the Privy Council, they observed that under the Hindu system of law, clear proof of use custom will overweight the written text of law. This means custom overrides the text. This fundamental principle laid down by the Privy Council, but the stand of Privy Council is criticized by the scholar because the scholars concluded that we have no such kind of evidence in Indian tradition where we can override custom over the written text of law. In this context, the view of Ganganath Jha is very crucial. Ganganath Jha written a book. Hindu law and its sources, where he highlighted that there is no single text or explanation which favors the opinion of Privy Council. Therefore, the opinion of Privy Council should not be accepted. In that context, where Privy Council suggests that written text of law may be superseded by the custom. But in contrast to the Ganganath Jha, Justice A.M. Bhattacharya ji wrote a book, Hindu Law and the Constitutions, where he observed that the law of ancient Hindu were really vox populi, means the opinion and belief of the majority, as the written text of law could be written of the voice of the people. So, we have two opinions on the opinion of Privy Council, and we can understand this. Now, the point is, the Yajnavalkya Smriti in chapter 2 and verse 21 clearly mention that in a case of conflict between the Smriti, custom will prevail. Means, so long as Smriti is clear, you are not going to quote the custom. But in a case of conflict, obviously you may follow the custom. Therefore, Yajnavalkya noted that Smrityo virodhe nyayastu balam vyavharatah. And in this context, the view of Supreme Court is also relevant. Therefore, friends, I quoted Syam Sundar Prasad Singh versus State of Bihar, AIR 1981, Supreme Court, page number 178, where the court observed that if there is a clear custom uses contrary the Shastras, then custom will prevail over the Shastras, and in a case of conflict between the Smritis, a judge would consult the prevailing practices among the people while deciding the cases. This is the observation of Supreme Court in regards to the importance of the custom. Now, I want to focus on the custom vis-a-vis the legislation. So, what we understand, that we understand the customs, kinds of customs. Now, I want to focus on how legislations of modern days treating customs. The legislature has always recognized the general legal force of custom. Either you approach any law, you are bound to find that they accepted the custom, especially when we are inquiring the family law. Then in a family law, generally law accept the custom, because family law is a living law which evolved through the practices of the society, and therefore obviously when we talking about the domain of family law, we are bound to accept the scope of the custom. In certain instances, custom have an overriding effect over the statutory law. However, custom may be disregarded if they may fail to meet the essential criteria required by their validity. Now, I want to focus and categorize the entire discussion in three different heads. The first is law adopted the custom. In number of places, law accept the custom. For example, section 7 of Hindu Marriage Act, where law recognized the ceremonies of Hindu marriage, especially Saptapadi, and Saptapadi is mandatory under section 7, and marriage will consider complete and binding after the completion of 7 steps before the sacred fire. Means law adopted the custom as it is. This is one area where law accepted the custom as it is. Now, we may identify the another set of practice where law provides space for the custom. For example, section 5 subclass 4 and 5 of the Hindu Marriage Act. Sapinda marriage is prohibited, but if custom allows, you may marry within Sapinda relation. Prohibited marriage is also prohibited within the prohibited degree relationship, but it allows when the custom permits. Now, friends, we also focused on the section 10 of Hindu Adoption and Maintenance Act, where after the marriage no adoption is possible. After the age of 15 years, no adoption is possible, but if custom allows, the adoption is possible. Means law provides the space for custom. The third relation is law overrides the custom. In India, we have also some Non-progressive custom, it is highly prohibited by the law. For example, dowry, child marriage, such kind of custom prohibited and restricted by the custom. Means we are able to draw the points, the relationship between the custom and legislation in three contexts. One context is law adopted the custom, law provides a space for the custom, and law prohibits the custom. After this, friends, I want to focus on the essential of the custom. Essential of the customs may be identified: ancient, invariable and continue, established by clear and unambiguous evidence, reasonable, not opposed by morality or public policy, not opposed by any law. These are the 6 important essential conditions of the custom. I want to explain the first, ancient. The custom should be very old to be accepted as a binding law. Old means custom must be ancient in its origin. Under section 3A of Hindu Marriage Act, the expression custom and uses signify any rule which, having been continuously and uniformly observed for a long time, has obtained the force of law. Friends, I want to explain you the meaning of observed for a long time. Under the English law, they use the expression time immemorial or time out of mind. And according to Halsbury law of England, time immemorial, time out of mind means time commencing from the King Richard, that is 1189 AD. They have a very specific meaning in the context of the time immemorial or time out of mind. But in the Indian context, a period of 100 years is the limit suggested by the scholar, because the span of life according to Hindu philosophy is 100 years, and every uses previous to it must be considered old and ancient, because they are beyond the human memory, therefore they may be considered as immemorial for Indians. This is the first criteria, that is ancient. Now I want to focus about a case, Gokul Chandra versus Praveen Kumari, where the court identified that a custom, in order to be binding, must derives its force from the fact that by long use it has obtained the status of law in force. But English rule of acceptance of custom should not be strictly applied to the Indian condition. Means English rules cannot be applied in Indian condition. The second is uniform and continue. Custom must be continuous. The rule should be observed on all occasions. It should not be accepted or rejected according to the convenience. Absence of continuity, we can't say that the custom is a real and valid custom. Continuity test may be differ in the context of ordinary custom and family custom. In a context to family custom, custom must not be discontinued, but in the context of local custom, the law of locality, it is binding on all the person within the local limits in which it prevail. Therefore, a single or few cases of discontinuity cannot deny the legality of the custom. Next important point is custom should be invariable, means it should be performed and followed in a same form. Now, the custom must be clear and unambiguous. The custom must be clear and unambiguous. Custom may be proved either by actual instances or by general evidence by the member of society. In a case of Lakshmi Bai, the court held that custom cannot be proved by the analogy or by logical process. It must be proved by the general evidence and actual instances. Onus of proof in a case of custom, the burden of proof as to the existence of custom rests on the person who argues that custom is contrary to the law. In context of family custom, the burden of proving that the family has abandoned the custom and has adopted the law of state, it has been settled that it lies on the parties stating about that. Now custom must be reasonable. In Baluswamy Reddiyar case, the court observed that custom among the Reddiyar community allowing a man could marry his daughter was held immoral and unreasonable, and such practices fail the test of validity. And custom also not be opposed by the morality and public policy. The idea is also very clear that custom should be as per the public policy and morality. Now custom should not be opposed to any law, custom must not be forbidden by the law, custom should not have been repealed expressly or by necessary implication by any legislation. For example, custom of giving and taking dowry is now opposed. The dowry related customs nowadays not recognized as a valid custom. Similarly, case happened in a case of prohibition of child marriage. Therefore, friends, we may think about certain things. The point is whether the custom that originated as the result of the conscience of the society be replaced or done away with by the enacting a legislation. What should be a minimum time period for which a use must prevail to upgrade as a custom or as a status of custom. How the Western concept of custom is different than Bharatiya concept of Sadachar. Friends, now I am concluding my today's lecture. We focused on the custom. What is custom? Custom is a practice. For a long time it is observed, therefore we recognize this is a custom. But meaning and concept of the custom in Bharatiya context and Western context are totally different. In Bharatiya context, we think that practice and conduct of caste people known as Sadachar, in absence of sovereign law and any textual law, we will recognize the authority of law from the conduct of the caste people. But in the Western country, a practice observed for a long time, for a time immemorial, therefore it recognized as a custom. We discussed the basis of the acceptance of the custom, where we discussed that we are not able to understand the true nature of dharma if we are ignoring the conduct of good people, therefore we should follow. In a case where the smritis are in the conflict, as per the Yagyavalkya Smriti, Smritya Virodhe Nyayastu Balam Vyavharatah. We also discussed the idea about the kind of custom where we focused on the family custom, class custom and the custom of a locality. We also discussed the different essentials of the custom, where we discussed the concept of ancientness, Indian and Western concept. Custom must be reasonable, must be continued, should be observed for a long time. Friends, very important is how we can prove the custom. We can prove the custom by the actual instance or general evidence, not by analogy or by logical process. For your concentration, I am thankful for you. Thank you very much. Thank you, friends.